It's Paul and it's
Megan,
and this is the ESPC Show. And this episode, we had a lot of chat on social media about this, isn't it? We thought it would be worthy of doing an episode on divorce.
yes, so a subject that obviously isn't the happiest subject. It's quite personal, obviously, as well, and something that we thought, in fact, Gilson Gray, who are the firm that are joining us today for this episode, got in touch and said that they think it's a really, hot topic just now. A lot of people asking online for advice and maybe getting legal advice from friends who've gone through divorces and things, and they obviously feel very passionately that you should go to a legal expert for legal advice, which we would advocate for as well. So yeah, we're chatting to Sally and Amy from Gilson Gray today to basically talk through divorce, and more specifically what happens to your property if you're going through a divorce, and what to think about if you're going through a divorce if you have a shared property.
Absolutely, and here's the episode. So here we go, welcome to the ESPC Show. We've got Sally and Amy. Probably first things first, do you want to introduce yourselves?
Of course, so I'm Sally Nash. I'm one of the partners in the family law team at Gilson Gray. So I deal principally with issues surrounding separations, but also cohabitation agreement and prenuptial agreements.
And I'm Aimee Orrock, and I work, I'm the corporate account manager for Gilson Gray, and I work somewhere between conveyancing, estate agency, and a little bit in lettings.
Okay, so yeah, good. And we were just talking before we went live there, just about clearly some of the topics we're going to touch on today is hotly debated online, social forums, etc. So it's really good to get the expert advice today. And shall we get the ball rolling? You've got the first question, I think, Megan, haven't you?
Yeah, absolutely. So we're hopeful that this week's episode is going to be a really useful resource for anyone who's going through quite a upsetting time in their life.
Yeah.
But I thought the first thing that we could ask is, if someone is in the very early stages of a separation and separating from their marital partner, because we're talking about married couples today, what's the very first thing they should do when it comes to their property?
I think the most important thing actually is to do nothing. I think that what we find is that after separation, sometimes understandably people are quite keen to make progress, and there's often a huge amount of focus on the family home, because for a lot of families it's the main asset. But if you rush into things, if you take steps too quickly, you can actually put yourself at a disadvantage, because more often than not, when you start looking into it, there are other assets that are taken into account. So we find if people take decisions too early about what's going to happen to the family home, they can't track back from that. So best bit of advice for that from a family law perspective is to stop, take a breath, get some advice before we start thinking about what to do with a property. And the other factor to bear in mind with that is that if you decide who you want to have acting for you as a family lawyer, if you instruct a particular firm to act jointly on a couple's behalf in relation to a sale of a property, then from a family law perspective, we're out, we can't act, because it's then a conflict of interest. So we often say to people, well look, quite often there's some huge issues involved in terms of dividing a couple's assets and dealing with a division of that. So, make sure you've got the right representation and don't effectively take yourself out from the person that you might have wanted to instruct because you rush ahead in relation to the property aspect in the first instance.
That's very good advice. And as you say, in the moment it's very hard to, but taking a breath. And you find sometimes, let's look for a happy ending here, that sometimes things people can reconcile at any point during the discussions, or generally when they're coming to you, is it over at that point? Or?
Oh, not at all. And we have people coming to us sometimes who actually, they don't know if they want to separate or not, and they just want to understand a bit more about their financial circumstances. And actually what I say to people in that situation is, well look, if you've got the information, you can then take a decision about whether or not to stay in the marriage, not because you're scared that you need to do something financially, or you're worried what might happen if the marriage comes to an end, but instead because you actually want to be in the marriage. So we absolutely have people who come to us who explore the possibility of separation and actually don't in the end because they decide they want to stay where they are. And equally, we do see people as well who separate because there's difficulties within the marriage, and actually do then find their way back to each other.
Okay.
So it's not all that usual, but
Sure.
it certainly
it can happen.
it certainly does happen. Yeah.
Okay. So how is it decided who gets what in the actual divorce? Who decides that?
So there's lots of different ways that can happen. So sometimes couples decide it between themselves. They'll come to us, they'll get some advice about, well, this is what the law says should happen in your circumstances. But one of the beauties of Scots law is that actually you don't have to do what the law says. You can make an agreement
Wow.
that's different. You can say, well, look, okay, thank you for. Sometimes clients say to us, well, that's great, glad to have the advice, not actually interested in it. We know what we want to do. We know what's right for us, for our family, and this is the way that we want to take things forward. So sometimes for us, what we're doing is what we call an implementation-only situation, where clients are coming and saying, look, and we can only act for one party, but they come to us and say, this is what myself and my spouse have decided. Can you just put this into a legally binding format for us? Ultimately, if a couple can't sort it out, either by themselves, with the help of solicitors, in negotiations, by alternative means of resolution like mediation or collaborative law, then the backstop, unfortunately, is always a court, and ultimately, if they can't resolve it, a court will have to resolve it for them in due course. But it's a lot. And sometimes people do need that assistance from the court, and sometimes that's for personal reasons. Sometimes it's actually just because the legal arguments are really, really complex and it's hard to get to a solution, and they need a bit of intervention from a judge to say, look, actually, this is what a fair division looks like. But for a lot of people, and what we certainly try to encourage people to do if they can, is to try, with our help usually, to come to a settled resolution.
Yeah, and I guess nobody's looking to fast track things here, but I think the process when you get a court involved, that's going to take longer, is it? Is there a long period before you can actually get to have the case heard, I would imagine?
Yeah, I think it definitely extends the period within that process, although I suppose it sort of swings around a bit sometimes, because sometimes people wait so long to kind of take, because they don't want to go. Who wants to go to court? Nobody does. But they take so long to make that decision that in actual fact, they end up in no man's land for years. And if they'd made the decision at an earlier stage to go into the court process, they might have been done quicker. But from our perspective, we always say to people, with expense in mind, with the trauma of it in mind, try and avoid court at all costs if you can. But as I say, sometimes there's really, really good reason why people can, and we're there to support people as family lawyers, whatever kind of format and structure the resolution looks like for them.
It's case by case, isn't it?
Exactly.
And so I had a little research online just about some of the most frequently asked questions about people who are going through this, and one of the things that came up a lot was, can I chuck my partner out? Can I prohibit them? Can I stop them from living in the house, the marital home? Is that something that's allowed?
It's again very sort of fact dependent. So and there's two different types of shared property, I suppose. You've got property that you jointly own and live in together, and you've got property that one spouse owns and the other lives there with them. In the first scenario, you've got two things at play. First of all, you're a joint owner of that property, and in theory, you're entitled to access it, to live there. And the second is that you've got occupancy rights to be in the property as well. Even where you are living in someone else's property as a spouse, you have occupancy rights as long as it's a family home, which means that you're entitled to reside in that property even if you don't own it. So the circumstances in which somebody can be excluded from a family home, it's a very, very high bar, and the only way to do it is to make an application to the court and to ask the court to exclude the person from the property. But as I say, it's a high bar that needs to be met, and the case law actually on it is a bit unclear at times, unhelpfully. But effectively, it can't just be that you're both miserable because you're separated and living under the same roof. There has to be a very good reason, such as, you know, domestic violence taking place, somebody's really not mentally well because of the pressure they're being put under by their spouse, etc., to get over that bar. And in particular, if a child needed to be protected as well, that would be a really a stronger basis for saying, no, look, the parent who's putting a child at risk, no, they've got to go. And quite sometimes we do find that even where it's a jointly owned property, actually couples agree that it makes more sense for one person to move out of the property, because actually it's not a happy situation for most people. I mean, some people, you know, separate and live under the same roof happily for years, and they just kind of, you know, they rub along situations where there's not been some big blowout. It's just a marriage that's you know, just come to its sort of natural conclusion. But for most people, it's not something that they want to do. And usually you can say, well, look, this isn't good for anybody. And, you know, perhaps we need to see people move into separate accommodation. But the problem with separate accommodation, of course, is that the person who's moving out needs to be able to find somewhere to live.
Of course.
And there's issues with that. Can the person afford somewhere else to live? Can they afford to let? Can they afford to buy? Do they need financial support from their spouse in order to be able to move out? So it's, yes, there are certain circumstances where you can say somebody has got to go, but there are usually other factors at play as well. Well, how realistic is it that they can go?
Is there an onus if they do move out? Is there an onus on the partner who's staying in the home to subsidise the rent on the property that the individuals move to, or is there any?
There can be, yeah. So for spouses, they have a financial. You've got.
So means tested.
Yeah, so it's you've got a financial obligation to each other, and I think people, you know, sort of the American terminology of alimony, people sort of think it arises out of a separation, actually the obligation to financially support each other actually arises because you're married. And
for better, for worse.
For better, for worse.
Richard or Peter.
And most of the time we don't realise we're alimenting our spouse, because you go to Tesco, you buy the shopping, you pay for a holiday, you pay the council tax bill, and that's us financially supporting our spouses. When one household becomes two, naturally a situation arises where the need for financial support becomes more stark. And in those circumstances, it's sort of means tested. So the test is needs. So what's the person who says they need the money? What do they need? So you take into account their income and their outgoings. And the interesting thing, well, I find it interesting, about the outgoings is that you're not looking at, well, what do they need to have a very sort of basic standard of living? The starting off point is, well, what do they need to maintain the standard of life that they enjoy during the course of marriage?
I'm now thinking about Kyle Walker and his, mind you, he wasn't married to that lady, was he? That's something separate altogether, sorry.
No. So, but
digress.
but so that kind of cut that, because, you know, so I always say to people, well, that means that if you spent £5,000 a month on Harvey Nichols during the course of the marriage, then first instance, when you're putting together your outgoings, £5,000 a month goes on there. And interim financials, it's a very interim thing. It's not intended to last for a long period of time. But the starting off point is that you should both be able to enjoy the same standard of living. The income that supported one household can't necessarily spread to support two, in which case people need to cut their cloth, obviously. But yeah, so if somebody was looking to move out and said, well, look, I can't afford to, you would say, well, this is what they need in order to be able to move out. And the other person can say, well, I'm looking at what you say you need, but that's a joke. You never went to the hairdressers that much when we were living together. Or they can say, look, I can't afford to pay you what you're asking for, in which case the whole test is needs, resources, earning capacity, and all the general circumstances, because we like to have something vague that we can work with.
Is that enforceable then?
Yeah, absolutely. Okay, right. So you would need to make an application to court to enforce it ultimately, and you would make an application and say, well, look, this is what I need from my spouse to be able, in order to be able to live. And quite often that does come to the forefront as I say, when one household becomes two and somebody moves out.
Okay, wow. I'm learning a lot.
Yeah.
So just thinking about the marital home, we've mentioned it a couple of times here. And again, there's probably no right answer or wrong answer to this, but when it comes to the property and divorce, is it best to sell the marital home or change of ownership to one party?
I think that entirely depends upon the client's position, our client ultimately. And that is where having valuation, desktop valuation, speaking to an agent, speaking to a couple of local agents, we do, we can be really discreet and we can do no obligation valuations, where you can really put your numbers down on paper, speaking to a good financial advisor, both parties, and then if it's amicable, coming together to decide if one person is going to remain in the house. Often when there's children involved, one party would prefer to live in the family home if that was achievable.
Stability,
If not, like Sally mentioned, sometimes you have to cut the cloth and you have to downsize together or move to different locations and separate areas. So it depends entirely upon their situation, ultimately their affordability and their drive to want to to stay in the
and the emotional attachment with the property, sometimes for good or for bad reasons. Sometimes it changes. Again, just going to depend, isn't it, on the individuals?
Absolutely.
And how do you work out how much of the shared assets each party is entitled to? Is it always 50-50?
No, not always. So first of all, we're looking to identify what is matrimonial. And one of the things that often gets forgotten about, and it's why financial advisors are so important, is pension entitlement, because pension entitlement can be so substantial, and so many couples are surprised to find that actually the value of their pensions is as big as the value of their other assets, such as bank account and the equity in their house. So, and pensions are a slightly funny one, how we value. We work out what it's worth at the date of separation, and then we apportion it in accordance with the length of the marriage. So what that means, if you've been in a pension scheme for 20 years and you've been married for 10, half the value is in the pot. So when we're dividing the assets, we look at that total pot and what's the net value of it. And what the law says is that it's fairly, which is usually equally, unless special circumstances justify otherwise. So the sorts of reasons why you might say, well, look, it shouldn't be 50-50. You can say, well, one person's been economically disadvantaged by the marriage and there needs to be some compensation for that. So a really common example of that is where someone's given up a career to stay at home and look after the kids. And the suggestion is not, in those circumstances, that anyone regrets that that was the decision that they made. It's simply that the factual reality is that as a result of taking a career break, the person's been disadvantaged. And they can be disadvantaged because it's 15 years later and the career they had is, if you have a career in, say, IT, the world's completely moved on and you can't just go back into the same
level
career.
You were,
Exactly.
The same goes for families that have been in the military or in kind of public service and emergency services, often in the military in particular, and any of the military bases, you move as a family, so it's really difficult traditionally for the wife, but also for the husbands who move, to maintain a career and develop a career, because you're moving every 2 years, so that comes into play.
Absolutely.
And often pension in that scenario was the biggest asset.
Of course.
100%. And military situations are very common in terms of economic disadvantage arguments. People say, well, look, as you say, I've never been able to settle down and have a career because I've been following you from place to place to place. And effectively what you're saying is that what this has led to is a loss of career, a loss of pension entitlement, because if you're not working, it's more difficult
Earnings
to build
potential,
it up. And a loss of income. So you can try and argue for unequal division for that reason. We've got a provision about the economic burden of caring for any children who are under the age of 16 being shared fairly. And you see some situations where you try and calculate the cost of particularly where one spouse, say, really does have most of the responsibility on a day-to-day basis for a child. You might try and calculate what it costs to raise them to the age of 16, which would make anyone shudder, quite frankly. But usually how that's looked at is, well, look, if there were to be an equal division of the pot, it would mean that the parent who's got the kids most of the time, and the kids wouldn't be able to stay in the family home. But if we were to divide the pot, say 55-45, the numbers would then justify, parent and kids staying at home. So that would then be a justification for unequal division. Or, for example, if someone's saying, well, look, I need a bit more capital to buy. I accept that the house has got to be sold, but it's not possible for us to keep it. But I need a bit more of the share of the proceeds. I need a bit more of that to make sure that I can suitably accommodate myself or myself and the children. And then that might be because one spouse has got better mortgage borrowing power, for example, and particularly where a spouse has been out of the workplace, it's going to be much more difficult for them to have that borrowing capacity than the person who's stayed in their career. So sometimes there can be an unequal division for that reason. And all these arguments, economic advantage, disadvantage, economic burden, source of funds, they're discretionary in nature. So when we're advising people, we always say, we're sorry we're talking about a court, but we've got to think about it. That's your ultimate backstop. And, ultimately a judge could look at this and say, yeah, discretionary arguments exist, but I don't care. I'm going to divide it equally anyway. Or a judge could take them into account, but how they then do that mechanically is a unequal percentage division. Does someone get back pound for pound what they've introduced? That varies hugely from case to case, and there's very little sort of certainty surrounding that. Although there's a sort of assumption of 50-50, and some cases are just pure 50-50 and it's straightforward. When you get these discretionary arguments, it actually becomes a very complex interaction that's open for negotiation. And I think it's all the more reason just to make sure that you're getting advice, because again, you see people who come to you who've just conceded 50-50 because they think that that's
the done thing, yeah.
Oh yeah, we've agreed, the house is already on the market, we're going to divide the proceeds, and they haven't even stopped to think what else might be at play. So yeah, it's all the more reason to take good advice from a family law solicitor, as Amy says as well, from other professionals who can then input into that. Is this a situation where actually you've got such an unusual property that you really might maximise value for everybody by putting it on the market? Because you must have situations like that where it's,
Yeah, we see it often. And then on the market, if you have a bespoke property, you have something that appears to be a certain way, or you go on. We have all these online calculators and they give you a desktop valuation, you input how many bedrooms and your postcode, and
it's not a precise science.
It's not precise, it really isn't. And the data is also usually out of date, it can be years ago. And in this market it's changing all the time. So it is really important that you get the right advice, and you're not Sally mentioned early on about conflicts of interest. If you have valuations done, you haven't instructed anybody, all you've done is got all the information and the figures that you need in order to make your decision, and you then ultimately still have a choice on who you would like to act for you on all sides.
Okay, so next question I'm just going to ask then, how long can divorce proceedings take?
I think it's very much how long is a piece of string.
Right.
I think to be honest, I think the quickest I've ever managed in terms of settling a case was about 3 weeks after separation. Because there was a lot of different emotions at play, and the parties wanted it done. For some people it takes years, and it very much depends on the process.
And it's about cooperation, isn't it? That's
exactly
the big factor in this, isn't it? If you get two willing parties, I imagine it can move forward. Yeah.
It does. And divorce proceedings themselves, because quite often what we are doing is we're sorting the finances first, and the divorce is almost a kind of tick in the box at the end. And if we're dealing with that aspect of it, usually 2 to 3 months the actual divorce is done. Where divorce takes time is where you're arguing about the finances or the children at the same time as you're arguing about the divorce.
Sure.
And then once that's common knowledge, family and friends start with opinions,
Yes.
and you know, that can
It
add to the
escalates,
timelines.
yeah.
It escalates. It can make things more challenging.
Yeah, good point.
And I think it's a really, really important, because I think everyone is so, you know, when you're going through a separation, particularly depending on the circumstances in which it's arisen, you know, your friends and your family, and it's lovely, they want to rally around you, but so many people get pointed in completely the wrong direction from well-meaning family members who care and want to see their person be okay, but in actual fact probably do extend the process and make the situation quite often worse rather than better. So we always say take support from your family and friends. It's fab, but take the advice from the professionals.
Yeah, emotional support over there.
Exactly.
Yeah.
Legal advice over here.
Yeah, absolutely. So obviously, well, I hope a lot of people don't get married to get divorced. So a lot of people probably don't think that they're going to be one of those couples that do that. But what is the best way to prepare for the worst case scenario? Do you get a prenuptial agreement?
I think they're becoming increasingly more common now, and it's something that I do a lot of, and people laugh at me, but I say there's actually a certain romance to doing a prenuptial agreement. and
We'll take that. That's going to be the TikTok quotes. We're going to just have that little clip.
But you know, because effectively what you're saying to each other is, look, you know, we're going to give each other a bit of certainty at the start of all of this. And prenuptial agreements in Scotland certainly don't tend to be, because again, you know, thinking about American drama series where there's clauses where if, you know, one person commits adultery, all these bad things happen. Prenuptial agreements in Scotland don't tend to be like that. What they tend to say is, well, look, we've got some fundamental principles here, which is that actually you're supposed to share in the income and efforts of the parties during the course of the marriage. Not what they had before they were married, not what their parents or their grandparents might pass down to them during the course of the marriage. So really, let's take what the law says, that these assets are protected, and let's extend it to something where there's a change in form as well. So there's a really clear boundary. This is ring fenced, this won't be in the pot, and all the rest is actually opening up for grabs. And that's what most Scottish prenuptial agreements will do. But we do sometimes see ones that have got specific provisions about properties and what's the range of options that might happen to them in the event of separation. You get the odd one where there's also specific provision as well on divorce. So you agree at the outset, if say one spouse has got masses of assets and the other doesn't, say, well look, I'm not likely to create anything that's going to go in a pot, but I will agree right now that if we get separated, I'll pay you X. Much more unusual, much more tricky to negotiate as well, because how do you determine what someone's worth? What's that price tag? So actually much more difficult to negotiate. But prenuptial agreements can, if there's particular issues that people are worried about, for example, if the house that they're living in did 90% come from granny, then they're relatively simple documents to prepare. The good news is that Scots law says that they're enforceable unless they're unfair and unreasonable when they were entered into. And although we do look at what the outcome is when we're assessing unfairness and unreasonableness, what we're really bothered about is, did the parties have an opportunity to take independent legal advice? Did they have plenty of time to consider the agreement? So if the bride's standing in her wedding dress 2 hours before the wedding and sees a prenuptial agreement for the first time,
yes, yeah.
probably not going to be
Probably
enforceable. Not. But even an agreement signed the day before the wedding, if it's been negotiated for 6 months before, could still be absolutely fine. So I always say to people, look, it's an insurance policy. And it's exactly what you say, nobody gets married in the hope or expectation that they're going to get divorced in the future. But you don't want your wedding venue to burn down either, but you still take out wedding insurance to deal with all those different scenarios. It's an insurance policy, it's done, hopefully it goes in the drawer, nobody ever sees it again. But if there's any anxiety, I think particularly about assets that are being passed down or that have been built up massively before the marriage, then I think it's worth doing. And what it means is that in the hopefully unlikely event that the marriage ends, rather than there being a big stooshy about, well, did that asset change form and should I be, there's really clear
it's
boundaries.
A lot more, yeah, it's transparent and clear, is it? I'd say what you've started with. It's what Granny would have wanted. Right, okay, so that's the romance of the prenup.
Yeah, on the prenup stuff as well, I think today we're talking about the topic of separation and divorce. And often, I got married quite young, so there just wasn't a conversation. We built our life together, so it just never came up. But in recent years, a lot of my friends are now on their second marriages.
Yeah.
And not only are they on their second marriages, they have children from their first marriages that ultimately they want to protect the assets that they have received or that they've built from their first marriage for the children. So it feels, the older I'm getting, the more of a topic this comes up. And like Sally says, it's far less of a taboo. When I was younger, I'd think you'd got a prenup if somebody was a multimillionaire and you were marrying into royalty or whatever, but that's not the case. Often it's sometimes it's about children and extended family members that you're also protecting. So.
Yeah, and I think you're right, you said about the fire on your wedding venue. This isn't you hedging your bets. This is just trying to make sure that everyone knows where they are before they start. Sally, Amy, that was really good.
Yeah, thank you so much for coming to join us today.
Yeah, we really appreciate it. Some really great advice there. And if anyone has got any concerns or would like to raise any of this, they can find you. How do they find you?
Well, they find us on Gilson Gray's website. So again, I'm Sally Nash. I'm one of the partners, and we're always happy just to have a chat with people and see how we can help.
Brilliant.
Okay. Same for me. You'll find me on the website, and I am happy to have a discreet conversation with anybody about desktop valuations. If you don't want somebody to come to the house, if you just want to gather some figures based on our market knowledge, we're more than happy to do that. The same for kind of the conveyancing side, and contact us and we will be discreet.
Thank you very much indeed.
Thank you.
Right, so there we go. That was Amy and that was Sally. Some really good advice in there. I think, two things stuck out to me. The romance of the prenup I thought was quite a poetic phrase, but also that thing about, you said at the start of the show really, friends and family for support, solicitors for proper advice.
Yeah. Absolutely. If you want to find out any more information about Gilson Gray, you can go to their website. We'll put all the links in the show notes as well. And if you're just looking for legal advice, you can search on ESPC.com through our member solicitor estate agents and find somebody that's local to you as well. But otherwise, we will be back next week with another episode.
We certainly will. So we look forward to seeing you all then. Thanks for watching again. Thanks for subscribing. Thanks for listening, and we will see you soon. Take care. Bye-bye.
Bye.